Good morning. We now reconvene the sixth meeting and the fifth public hearing of the Special Select Committee of the Senate on the Sexual Offences Amendment Bill 2019. This hearing is being broadcast live on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I want to thank the entities which have been invited and which are before us this morning. And at the first stage, we'd go through the introductions. I am Clarence Rambarat. I'm chairman of this committee. And I now invite the other members of the committee, who are all senators. This is a Senate Select Committee, to introduce themselves, starting with my colleague on the right.
Good morning, Anita Haynes, member.
Good morning, Sophia Choate, member.
Good morning, Gerald Rambin, member.
Good morning, Paul Richards, member.
Good morning, Alison West, member.
Good morning and welcome all of you. I am Jennifer Baptiste Primus and I am a member of this committee.
We are also supported by the representatives from the Office of the Attorney General and the representatives from the Chief Parliamentary Counsel's Office, together with the secretariat that is provided by the Parliament. I expect the Honorable Attorney General to join us at some stage. He's in another meeting at this time. Today we have before us the representatives of the Rape Crisis Society, the Institute of Gender and Development Studies, UE, the Organization for Abused and Battered Individuals, the Trinidad and Tobago Association of Psychologists, and Kaiso, Sex and Gender Justice, TNT. On the last occasion, I indicated that we would have before us, and we invited, Women Working for Social Progress. But that organization has indicated it is part of the coalition of NGOs which appeared before us on the last occasion, and therefore they would make no further comments or written or oral submissions. The Caribbean Association for Feminist Research and Action has also been invited and has undertaken to provide written submissions, but is unable to attend today's hearing. And finally, notwithstanding the previous comments by the Institute of Gender and Development Studies, UE, as part of the submissions from both the Ministry of Education and the coalition of NGOs, the Institute is before us today and has also undertaken to provide additional comments by Thursday, March 21st, 2019. I now want to invite the entities which are before us to introduce themselves, starting with the Rape Crisis Society and proceeding in this order. The Rape Crisis Society, the Institute of Gender and Development Studies, the Organization for Abused and Battered Individuals, Trinidad and Tobago Association of Psychologists, and we'll close with Kaiso, Sex and Gender Justice, TNT. I see Mr. Robinson is in the front panel. So I invite you, the Rape Crisis Society.
Good morning, I am Paula Hospitalis, Treasurer of the Rape Crisis Society.
Good morning, I'm Elizabeth Johnson, a member of the management team, Rape Crisis Society.
Good morning, I'm Dr. Gabrielle Hossain. I'm the head of the Institute for Gender and Development Studies.
Good morning, Dr. Diane Douglas, clinical psychologist.
Good morning, I am Delreen Liverpool Young, legal counsel for Organization for the Abused and Battered Individuals.
Good morning. Good morning, Jonathan Bargan, member of the Organization for Abused and Battered Individuals.
My apologies for my eagerness. Good morning, I'm Dr. Khatija Khan, the immediate past president of the Trinidad and Tobago Association of Psychologists.
Good morning, Dr. Karen Moore, clinical psychologist, member of the Trinidad and Tobago Association of Psychologists.
Good morning, Senators, parliamentary staff, CPC, and ministerial staff and colleagues. I'm Colin Robinson, Director of Imagination for CAISO, Sex and Gender Justice.
Hello, good morning. I'm Dr. Angelique Nixon, a board member of CAISO, Sex and Gender Justice.
Okay, thank you very much. Today is Tuesday. We are all senators. We have a sitting of the Senate this afternoon, which involves today a debate on a bill that is now being read the second time. So the purpose of this hearing is to allow you the opportunity to express views or expand on specific aspects of your written submission. This bill was in debate in the Senate, and the Senate agreed to have the bill considered by a select committee, a smaller group of senators, with your support. So the purpose is to hear from you. The members will ask questions or make submissions relating to what you've put before us in writing. I intend to go to noon, and I want to assure you that if for any reason, when you leave here, you believe you have something additional that you wish to submit to us, you are free to do so in writing. After this, the committee goes into 3 additional meetings where we consider the technical aspects of the bill in 3 meetings in a clause-by-clause analysis. But if it becomes necessary to seek any further submissions from any one of you, the committee will do so in the manner we've already done. So I want to assure you that this is not your last opportunity to be heard. Based on what transpires today, you have an opportunity to make further submissions on any matter you wish to bring to our attention. I want to invite, as soon as the name cards are sorted out, I want to invite my colleague, Member Anita Haynes, to open today's discussions. Thank you.
Thank you once again for joining us here today as we look at the amendment to the Sexual Offences Act. I just want to move quickly, going through all the submissions presented to us. There were a number of comments in terms of the nature and purpose and outcomes of the register, which formed a big part of our consideration. So starting with the Trinidad and Tobago Association of Psychologists, I noted certain comments raised with respect to the register and its implementation and outcomes. So I would like for you to start there and share your concerns and recommendations.
So again, the association is thankful for the opportunity to contribute to this valuable discussion. Outlining some of our concerns, it was with respect to the first concern, the nature, purpose, and outcome of a register. So first, the implication of the amendment as it is that all names that are added to the register will also be made, would also be placed on the public register. So our first concern was about whether all sexual offenses would be made registrable, and we have similar concerns to those shared by other stakeholders about including some types of offenders on that list, for example, mandatory reporters and sex workers. And there is no qualification to distinguish them from other types of offenders. To illustrate with another example, if we take the issue of mandatory reporters, if the overall intended outcome by having someone placed on a register is to increase their compliance for reporting, then we have to ask ourselves, how is this best achieved? Now, what we know about theories of learning and behavior change is that things such as reinforcement or removing the barriers that are currently there which prohibit people or deter people from reporting would be more effective strategies than, say, having people placed on a register. So attendant to that would be the need to review thoroughly the mechanisms and protocols that currently exist for mandatory reporting and how they might be deterring people from reporting more effectively. Our other comment was with respect to a consideration of a tiered risk-based system, which has been spoken about. And we consider it's not without merits because it takes into consideration different typologies and the different risks and rates of different offenders. For example, incest offenders amongst the least likely of sex offenders to recidivate, whereas offenders who have extrafamilial male child victims are among the higher risk offenders. Having a tiered system means you can assign a risk level to offenders, and usually the least risk offenders are not placed on a public registry. They're kept on a private register, but not on a publicly accessible register. Another note is that current risk-based risk assessment measures, as well as current typologies in the literature, do not make considerations for categories such as mandatory people who fail to report, and also for sex workers. So that would be a challenge to consider: how do we assess these people for risk? Our second concern concerns the distinction between registration and notification. We provide in our submissions some detailed submissions, but just very briefly, the notification laws mandate the dissemination of information to the public, and that is a briefer or more limited information that is contained in the registration laws. The purpose of the notification laws are to enable greater public awareness, which will facilitate offender avoidance, public monitoring, and public identification of a suspect. We are concerned that there is not a clear distinction between the terminology that's being used to represent what will be available to the public in a registry and what will be maintained in the private registry. As it is, we just speak about a register. So I think it would be helpful to have more distinct terminology, which will help the public and users of the system and people who are maintaining the system to inform them about what are the distinct types of information that, say, the public is entitled to. So, for example, you're entitled to a criminal history and a physical description and a home address, but you're not entitled to know where the person is going to school, where they work, what their license and registration number is, etc. Our third concern addresses the overall efficacy of the use of sex offender registers. The research is quite mixed. There are some studies that suggest it is associated with a decrease in recidivism. However, some studies also suggest it could result in an increase, and some studies show no improvement. Some studies also suggest that there are these unintended negative outcomes through increasing public anxiety of knowing that there's a sex offender in your community, and also it can exacerbate and further reinforce inequality and exacerbate unemployment, harassment, and homelessness in the sex offender community. Now, in that regard, we cannot assume that the introduction of a register is going to have a positive impact on recidivism rates. In order for us to establish that, we need to study it and validate it in our local context. So our concern was whether there was a consideration for a study of the impact of the introduction of a sex offender registry. So consideration for data analysis, data collection and analysis, which can capture recidivism rates, victim impacts, community perception, and offender perceptions. Two other concerns concerning the register. One of them, the other one is pertaining to the maintenance, the fidelity, and integrity of the register. We note that there is precedent for other agencies having responsibility for registers, for example, Attorney General's Ministry of National Security, Commissioner of Prisons, etc. So we were just wanting a little more information on the rationale for vesting the responsibility within the Commissioner of Police, as well as what were the considerations for the capacity and resources available for that office to undertake such a responsibility. With respect to the information to be collected and provided, the amendment recommends every 6 months, but there is no, for reporting to the nearest police station, but there was no specific mention of the frequency and the provision of information. So, for example, a photograph, how often should a photograph be provided? And this is, of course, more pertinent for offenders who are on the register for a long duration. So for example, if you're on the register for 2 years, a photograph across 2 years may not differ. However, if you're on the register for 15 years, my photo 15 years ago may not resemble me very much. So consideration for the frequency of provision of information, as well as whether proof of address is required, and also whether verification of address is going to be undertaken. Some of the studies have suggested that maintaining an effective registry is contingent on having valid and reliable registers. Now, the amendment does include penalties for non-compliance. However, studies have noted that persons who have longer durations to report were less likely to report changes. So therefore, there was an increased likelihood of having incorrect, outdated information on the register. Now, if a person provides a false address, they can be penalized, but until that is investigated, prosecuted, etc., then the overall aim of providing accurate information to the public is going to be compromised. So our question is will there be a body who is statutorily charged with verifying information provided by offenders? Our third consideration pertains to the misuse of the registry. So while the aim is to safeguard the public, as I mentioned before, some of the unintended consequences are increased anxiety in the community, but also offenders report many barriers to their reintegration into society, namely harassment, difficulty with housing, employment, physical and verbal assaults, impaired relationships, and also their family members are affected. Now, the vast majority of offenders will return to communities, and they will need to be reintegrated back into communities. So we need to consider how the potential misuse of a register can be in hindrance of this aim. Persons who intend to use it for malicious or discriminatory purposes. One of the examples we found was from the New Jersey Sexual Offender Internet Registry, where they provide guidelines for the use of their internet registry. They ask users to read and accept, to click before they proceed, acknowledging that they're not going to misuse it. But also, they have specific penalties and consequences for misuse. So, for example, they say that the law expressly prohibits the use of the registry information for the purpose of denying or obtaining health insurance, insurance, education, loans, business, housing, accommodations, etc. It's punishable by a term of imprisonment of between 3 and 5 years and a fine of $15,000 US. So our concern was, are there considerations and provisions for the potential misuse of the register, both for the information that will be held by the Commissioner of Police and for the information that will be publicly available?
Dr. Khan, I want to ask you to pause so that we could have some discussions on your first 3 submissions. But
Thank you, Chair. That was actually the end of the comments pertaining to the register.
Right. I see you have, your next section deals with the way forward, right?
Yes.
Right. I want to invite Member Batiste Primus to pose a question, and then we'd move into a broader discussion on what has been said so far.
Thank you kindly, Chairman. And my question is directed to the Institute for Gender and Development Studies from the University of the West Indies, 2 representatives, the head of the department who is with us, Dr. Gabriel Hussein and Dr. Diane Douglas. We have not had the benefit of written submissions from your department, and therefore I am particularly interested in receiving the views of the Institute for Gender and Development Studies. And perhaps you can start, Dr. Hussein. I know you may have a presentation. Section 39 speaks to the introduction of a national sex offender register.
Good morning, members. The Institute will be providing our written submission on Thursday morning in time for consideration on Thursday afternoon. However, Dr. Diane Douglas is also here representing on behalf of the Institute for Gender and Development Studies as part of our support to, for technical expertise to this committee. There are a number of key just observations that I'd like to make, and then we can engage a bit more. The first is that in the Caribbean, the data shows that legislative change is in itself not a panacea for the kinds of problems that we're experiencing, and this is well documented in relation to domestic violence. And so it is key, I think, that this legislation be accompanied by a strong emphasis on the institutional structures that accompany it. In other words, where the register is meant to keep a record of those who have been convicted of sex offenses, but where we know that there are low rates of reporting. Low rates of reporting mean that there are low rates of convictions. And therefore, only those cases that result in convictions end up on the register. Those who have committed sex offenses with impunity, either because of underreporting or because they fall out of the system during the process of going through the courts. Those do not, and that would, we would argue that would be the majority of cases, those do not end up on the register at all. And so the arguments around protection of the public, the arguments around being able to get information in terms of who has access to children, who has access to the elderly and vulnerable, the register, in the context of the register needs a process of improving access to justice more widely for it to function as it should. And so we would like to place on record the fact of the low reporting as a key challenge and a key consideration, for it means that those who are committing sex offenses and have not resulted in convictions will remain off the register. And so for that to be a consideration. The second thing is that reporting itself remains risky. And I know that has been part of the presentations made to this committee before. And so the register's strength and relevance comes from strengthening the protocols and the protections for those who report. Reporting is the first step in the register's strength, in other words. And where reporting remains an issue when there are not sufficient protocols or protections, it means that actually the register will deal with a very small number of offenders in relation to who it should actually be addressing. And so building an institutional structure around this, given that legislative changes have not ended the kinds of problems that we are seeing, is, I think, key. The third thing that we would just like to emphasize is the question of child sexual abuse and incest, which has been raised again by the coalition, which is to say that given the rates of child sexual abuse and incest in the country, we have to specifically think about what the implications are for the families of those committed of sex offenses and on the register, when it is that the entire families can now become vulnerable to public scrutiny and to public knowledge, and therefore to the shame and stigma associated with this issue. Finally, when we look at the rates of intimate partner violence and intimate partner sexual violence that women in Trinidad and Tobago report, in addition to the rates of non-partner sexual violence that women in Trinidad and Tobago report, what we also see is that the rates are so significant. Around 20% of the population of women report non-partner sexual violence, and up to 1/3 report an intersection between physical and sexual violence in Trinidad and Tobago. That the rates are so significant that if all of those were to result in just convictions, there would be so many perpetrators on the register that were we to proceed in this way without the proper therapeutic, community, restorative, or other approaches, we would be facing an inability to deal with its consequences if we don't anticipate them at community and family levels. I don't know if Dr. Douglas at this point, having come under the auspices of the IGDS, would like to make some comments, if that's okay.
Thank you so much for the opportunity to be here to give this perspective. The only thing that I would want to add has to do with the support around this issue of the register. I think it's very important that at the point of sentencing, that there is some system that allows for psychologists to have a seat at the table. It is very important that there are assessments made available to the judges and magistrates so that they have this information to make an informed decision. Because the issue is that we want the offending to stop. We do not want people to go through the system, and we are very careful about the issues of recidivism. And so it seems to me that it would be very, very important that there is a system that is multidisciplinary that can inform the court about situations where reoffending might be fairly high. And for those situations where reoffending will be high, I see it as very appropriate then for those cases to be put on the register. This issue of having a rights-based approach to the treatment of the complainants and persons that I would call vulnerable witnesses. This is very well documented in the model guidelines for sexual offense cases in the Caribbean, put out by the Caribbean Court of Justice. I do believe that if we then develop specialty courts to deal with issues of sex offense, sex offenders, etc., you will then have a system in place to be able to deal with reoffending and for those who will be placed on the register. As it stands right now, we do not have that kind of system in place, at least based on how the bill has been constructed. And so there are so many loopholes that it makes it very possible for persons to reoffend. My dear colleagues from the Psychological Association, of which I am a member, and I fully support what was being said, is this issue of the vulnerability of the witnesses. And I think this is something that it would be wonderful for the committee to take into consideration. Our society is one where we are woven together with each other. And because of that weaving together and very community-oriented approach to life, a register that comes out of, or a system of registry that comes out of a North American context may be best practice, but it may not be the best fit for a society like ours, for Trinidad and Tobago. And so when you have a situation where a person is dependent on one family member who might be the perpetrator, being abused by the person who is perpetrating the sexual offense, and then if that person who is receiving the abuse or the victim of the abuse is a child, you then have situations, if this person's name appears on a register, where you have community members who might inflict further trauma on the persons who became a witness, and saying, you are the person who caused this person to be on the register. You are the person who did harm to our family member. You are the person who caused. So there is a lot of opportunity for the re-traumatization of the child and the re-traumatization of a person who's the witness, long after the case has been dealt with and long after the person is placed on the register.
Okay, Dr. Douglas,
yes.
Thank you very much so far. I want to invite the Kaiso to highlight from your written submissions. You submitted an update this morning to highlight for us the key aspects of your written submissions, particularly those which have not already been discussed.
Thank you, Mr. Chair. First of all, we want to express our appreciation that this bill has been sent to a special select committee and that you have invited a dozen civil society organizations. We hope this sets a model for legislating. Dr. Nixon is here with me today this morning in part because we believe the voices of survivors of sexual violence need to be heard more by the committee. We're grateful that clinicians' voices are heard. We would appreciate if criminologists had more input in the design of the legislation as well. There are three key issues that we highlight in our submissions. One, we support the position of the coalition, but want to emphasize that the approach to the criminal justice approach to sexual offenses should be security versus shame-based and risk versus offense-based. That registration decisions should be part of a judicial sentencing framework following an assessment, and most importantly, we can't stress enough that there be continuous rehabilitation interventions and assessment for all convicted offenders to ensure their reintegration and prevent reoffending. This is an important step towards procedural and restorative justice that the Parliament can make. Secondly, we want to thank the committee members who've raised concerns about the registration of for victimless offenders and who've drawn attention to sections 13 and 16 of the Sexual Offences Act, which were amended by the court in the Jason Jones case. The Attorney General has sought to reassure you that those amendments prevent people who are engaged in consensual activities from entering onto a register. That would be reassuring had the government not appealed the case. So at any moment, it could be overturned by a higher court, returning consensual homosexual conduct and heterosexual anal penetration to their old criminal status, empowering the state to sweep into the bedrooms of tens of thousands of citizens and convict people for mutual pleasure and put them on this register as homosexuals and sodomites. And we hope that the legislation will find a way to avoid that. Finally, we wanted to raise a new issue, we think, in the debate, and that's the idea of a duty on the part of institutional leaders to verify that persons in positions of trust, clergy, education workers, caregivers, as examples, are not sex offenders. And that we think that enabling that duty ought to be the core purpose and function of an offender register, and that there should be penalties, that duty should be created in the legislation, and that there should be penalties for failure to verify that someone being hired or retained in a position of trust has not been verified as safe to do so. And we propose that there be a yes-no verification process in an otherwise confidential register, and that that function also be available to individuals with a demonstrable need to know, for example, someone who is hiring someone to take care of a minor. So those were our three concerns.
Thank you very much. I want to invite Member Paul Richards.
Thank you, Chair, through you. Good morning again, everyone. My question is for the Department of Gender Studies at UE and also the Association of Psychologists. Many of my and certainly my colleagues' presentations in the Senate and in these deliberations have come about because of our perusing of international research documents. Based on, in particular, the Department for Gender Studies and your work in research, can you specify any deviations of typologies, prevalence, or etiologies of sex offenders that may be unique to Trinidad and Tobago, or situations that we may not have considered that may be prevalent in other jurisdictions that because of our culture and societal makeup that we may need to consider in Trinidad and Tobago? And this is, of course, through your existing research or research you may have come across in this jurisdiction or in the Caribbean at large.
Thank you very much, Senator. I would say, based on the experience as a clinician, there are two categories that I have not seen in the typologies that we see in North America and in other places where we readily have available research. One has to do with communities where incest is seen as the norm. And unfortunately for us in Trinidad and Tobago, we have communities like that, where an incestuous relationship with a child, for some, is actually seen as a right, that it is part of a rite of passage. And so what happens, some of these children, of course, grow into adults and then continue with the same mindset that it is okay then to be sexual with a minor. Another category would be the category of those who are of low intellectual functioning, that their intellectual functioning tends to be compromised in some way. And sometimes they don't always understand boundaries, especially if they have been the victims of sexual violence themselves. And so we've had situations in treatment where we found persons who are struggling to understand that not because a child seems precocious in some way means that the child is inviting you to have sex with them, and because this happened to you means that this is the appropriate behavior. And so for persons like that who can be taught the difference, we see a gap in the parenting that would have taken place for that person where it was never brought to bear on the appropriate boundaries for sexual behavior. So those would be two areas of consideration for me, Senator, based on your question, that I do not feel they are always captured in the research external to our country.
Okay, thank you. Dr. Douglas?
Dr. Moore, also.
Yes. Good morning, everyone. I wanted to qualify a little bit what my colleague Dr. Douglas had said in terms of communities where incest is regarded as endemic. That is something that you will also find in countries abroad, not so much in terms of a community as in terms of, say, there's a subculture within certain groups that have come together. So, for instance, in the UK years ago, there was a subculture around cult or ritual abuse of children. So there were various cult organizations, and sexual abuse of children was a normal part of many of those subcultures. So it may not be as open here as it is in some of our communities, unfortunately, and she's quite correct, where it is considered perfectly okay, but it does exist at a subculture level. So there are communities where that is considered the norm. And as she says, the children, adults, the grown-up children will pass it on.
Thank you. I want to invite the Organization for Abused and Battered Individuals. And I want to direct your attention to three parts of your submission. The first is you've recommended an implementation and oversight committee. That is one. Secondly, you've raised comments on the public aspects of the registry. And the third area is that you have proposed the 3 strikes rule for minor offenses. And I want to get those submissions in addition to anything else you want to say.
Thank you, Chair. Sorry. I will deal with the implementation of the Oversight Committee, and my colleague Jonathan Bargan will speak to you on the public access to the information on the registered sex offender. So the 2 latter points Mr. Bargan will address. In relation to the Overseeing Committee, our organization believes that this act, a key part of this act would be the implementation plan that goes along with the act. So we recognize that Section 39(3) of the bill basically just states that the Commissioner of Police shall ensure that information is entered into the register. But mindful of the crime situation and the burdens placed on the Commissioner of Police and the entire TTPS at this point in time, we think that the act should mandate that the TTPS implement or set up an overseeing committee to deal specifically with the registry. I would even go further to say that the legislation should also mandate a specific time frame by which this implementation committee could be set up. Additionally, we think that the act should also mandate the composition of the committee. And we would recommend that perhaps maybe 1 or 2 representatives from the civil society, maybe psychologists, would be able to sit on this committee for all registry processes. We think that a committee such as this would have within its terms of reference to develop guidelines for how persons would be placed on the register. They would be able to review cases with respect to placing individuals on the registry, review appeals for expungement and requirements for placing someone on the list. We also think that this committee may deal with also, as I said, expungement from the list, because we saw in the act that it is the court that will now decide whether or not a person would be removed from the list, and we thought that this might be a heavy administrative burden for already burdened court system. I'd also like to interject at this point, we also think that the act should mandate not only a register, but perhaps a database, that the TTPS or the committee should establish a database to house the information as required. We envision a database that is not in silos, but one that would be able to, we should be able to track offenders and provide real-time notifications to officers stationed at various police stations concerning the release of offenders and those traveling or returning to Trinidad and Tobago. This database, we also envision, would provide notifications to complaints or victims where the proposed date of release of the offender, perhaps from the prison service, where their current address. This would prepare the complainant and thus reducing the trauma, and the complainant would therefore be able to protect his or herself. We also envision an encrypted security providing response, seamless, and real-time interagency linking and information. So when in situations where you have perhaps sexual offenders coming from the United States being deported into Trinidad, their information should also somehow be captured on this register and database. Thank you.
Should I begin, or are you? Okay. So my name is Jonathan Bargan. I'm an attorney at law. So on the point of public access to information on the registered offender, the organization's position is that information about a registered individual revealed online should be limited to what is necessary to promote public safety. For example, any information such as the place of employment, place of education should not be routinely available. And further to that, keep in mind, members of the committee, that our Constitution is the supreme law of Trinidad and Tobago, and that we have a right to private and family life. And the legislation touches on concerns not just the right to private and family life of the offender, but keep in mind we are a small society. We love bacchanal, we love scandal, we love gossip. So there's potential for an entire family name to be scandalized for generations. So in keeping with Section 13 of the Constitution, that whatever legislation is passed by Parliament, even with the special majority, has to be reasonably justifiable. Keep in mind that is what struck down certain laws in the Jason Jones case. Again, even if the Parliament passes it with special majority, this law can be challenged. If you look at the US, which is the only jurisdiction with a public sex offenders registry, there are endless regular constitutional challenges to Megan's Law and the international Megan's Law. And, well, as I have a colleague in the US Department of Justice who says basically in their view of constitutional law, security trumps everything else. But that is in a different jurisdiction. In our jurisdiction, I do not believe the Privy Council may uphold this legislation unless we show that it is proportional, that the rights are proportionately derogated from, and that it is reasonably justifiable. So I'm recommending, in addition to our comments, that some sort of tier system be put into place. I think you'll be familiar with the Pareto principle, that it's a principle, it applies to criminology and generally in nature, that the 20% or a small fraction of your offenders are going to be producing the majority of your offenses. The upper 20% produce 80% of the crimes. So you want to be looking at the really high-risk individuals, and you put them on the registry, the pedophiles who rape 50 or 100 children in their lifetime. And while those statements may sound exaggerated, there are recorded instances in the US and other countries of somebody molesting 500 children in their lifetime. One of them is a Jack Sporek from California. So these are the individuals in those cases that I believe it would be reasonably justifiable to infringe upon their right to private and family life and their families' rights, because they're such a huge risk to society. But if you were to put a 19-year-old boy who didn't understand sexual consent and fooled around with a younger girl in that same category as this person who is an actual monster who cannot be redeemed, that would be a serious infringement upon the right of this younger boy who might be reformed. So I know when you're putting people who are low risk on the same list as people who are high risk, you're also diluting the effectiveness of the register. So whatever is made public should be a statement saying, it should be only people who are real risk to society, and it should be proportional to the constitutional rights. And let me just touch on the last point, the 3 strikes rule. We believe that where offenders have 3 or more convictions from minor offenses, they should be made to register for a long duration. So in our research dealing with sexual recidivism, there are individuals who basically refuse to cooperate with rehabilitation procedures and who refuse basically their rehabilitation despite counseling being available, just does not work out. So if we believe an individual who falls into that category of a high risk based on their 3 or more convictions should be made to register for 20 or more years due to the risk involved. So thank you very much.
Thank you, Mr. Bagan. I want to ask the Rape Crisis Society to make their submission to us, but I want you to open with, at the end of your submissions, you've made 4 recommendations. So I want you to open with your submission relating to bail, and then highlight for us anything else in your submission you want us to consider.
Thank you very much for the opportunity to respond today. Our first submission is with respect to bail for penetrable sexual offenses that are committed upon minors. We have the view that they are the most vulnerable and that all measures must be taken to protect them. These 2 will include reports of incest, where the victims are these minors. It may happen at their home, and we want to take extra precaution to make sure that these victims are protected. The second one that we spoke about is the NGO's response to assisting victims of sexual offenses when they have the option to be taken before a medical examiner to be examined for the purposes of finding out if they are suffering from a sexually transmitted infection. We are recommending that the legal body responsible for preparing witnesses to testify, they explain all the options, all the legal disadvantages that may be available if it is they are not willing to become medically examined. We have seen where, because of the length of time a court matter involving this nature takes, by the time the victim decides to be medically examined, and this is under Section 35(4) of the Act, by the time the matter is determined and they decide to be medically examined, all the evidence that may be adduced from that medical examination may not be valid. Sometimes, too, if the victim or the virtual complainant decides to be medically examined, it may create a clean slate for both the virtual complainant and the accused, in that, too, it may satisfy the court when looking at the intent. If the complainant is, if the offender is, if the offender has contracted a sexually transmitted infection and he or she is aware that they have contracted the sexually transmitted infection and they are deliberately infecting others, we are of the view that the court can look at that at the initial stage of the matter to determine the mens rea of the accused person, in addition to which, knowing the status of the victim, who may be in a better position to receive compensation as provided for in the Act. We also looked on the part of compensation. We also looked at the option available for them in the criminal injuries legislation, where it gives the victim 1 year to apply for compensation. We are asking that the criminal justice procedure as pertains to this law create some opportunity to give a little flexibility in that provision, because it has become practice. We have seen it, that a matter involving this nature does not take 1 year to complete. And we don't want to put our virtual complainants in a position where, if they are eligible by facts for some sort of compensation, that they are unable to receive it because of a deadline that was not reachable, and it's not their fault that they were unable to act within this deadline. Our third submission, we spoke of the psychological risk assessment tools and psychological intervention strategies that were not catered for in the legislation. We are also of the view that assessing the alleged offender and even assessing the virtual complainant can assist, as mentioned by my colleagues before, can assist the court when they're looking at the sentencing options. We know that some sexual offenses may be one-off offenses, and in some cases there may be repeat offenders who are finally caught, or they continue to commit offenses whilst on bail. So we are recommending that some legislative measure be put in place where NGOs can assist the process to assess persons before sentencing. In addition to which, a simple example of where it exists is in the Domestic Violence Act, where at the end of Section 6(1)(c), the court orders that persons can go for counseling, and that is a court order. So in light of that, we are looking at both the victim to assist the court process and the offender in terms of assessment be factored into the legislation in a manner similar to what is written in the Domestic Violence Act. Our fourth submission speaks to the sanctions that are available in the legislation for when an offender fails to report as required. Section 4510 of the bill, we believe, should be strengthened, where the designated officer, who is a sergeant of police or above, monitors the sex offenders with respect to reporting and providing the information that is listed for the register. However, if an offender is placed on the register and he chooses not to report and he is in hiding, we have found nothing to indicate how he can be located and how to enforce him or her coming before the courts to answer why he has not been reporting. And we haven't seen any strength to impose any of the sentences mentioned, which is fine and a custodial sentence. We are recommending that the designated officer, whoever is appointed by the Trinidad and Tobago Police Service, he, by law, be mandated to take the necessary steps to search for and locate that sexual offender, and those steps must be structured so that all bases are covered. And when the sexual offender cannot be found, he may apply or petition a magistrate under oath for a warrant to be prepared for the apprehension of this offender. We are also recommending that this power of arrest under a warrant can also be given to the chief immigration officer in case the sexual offender is desirous of absconding from the jurisdiction of Trinidad and Tobago. Thank you very much.
I want to thank you very much for your comprehensive submission. And before I invite the Attorney General, he's indicated to me he has some questions to ask. I want to go back to Kaiso and ask you to just very briefly talk about the show cause submission you've made. And that is a good starting point for the Attorney General. You've made a submission relating to requiring, it has to do with entry onto the sex offenders registry, and you've said an equitable process for offenders to be removed from or show cause why they should not be entered on a registry. And just very briefly, I invite you to talk about that.
Thank you, Mr. Chair. The coalition that we're a larger part of has been asked to make a written submission which will clarify the coalition's position. Whichever mechanism we end up with in the legislation, we'd like it to be equitable and not to punish low-income offenders.
Okay, thank you very much. Honorable AG.
Thank you. Good morning. And may I express my profound gratitude to each and every one of you for very fulsome and well-thought-out submissions from very unique perspectives. Certainly as the drafter of the law, it is very useful to have your submissions for my own part, and I'm sure I speak on behalf of the committee of senators. Obviously, I'm not a senator, so I'm technically the guest as the drafter of the bill before us. I have a few very pointed questions to assist in consideration of the submissions, and I think I can perhaps address them to Dr. Khan in the first instance and anyone else who may feel the need to chime in on this. I'm interested in your observations about care, if not exclusion, for two categories of potential offenders for sex registration. And you mentioned those who would be caught by the mandatory reporting mechanisms, which obviously is Section 31 of the Sexual Offences Act. And also you mentioned the category of sex workers, which I construe to mean persons who are living off of prostitution in accordance with Section 23 of the Sexual Offences Act. I'd like to just ask a question squarely as to how to disaggregate that pot. Is the pimp and prostitute in the same position, particularly in the trafficking in persons double layer that may happen? And I'll explain it so that the listening public understands in your submission. Let me put it this way. So people who are found guilty in a court of law of failing to have reported sexual offenses find themselves in the circumstance of guilt only if a court decides that they don't have reasonable excuse not to have reported it. So it isn't a strict liability offense. It goes through a court process, and the court says, you, Mr. Doctor, or you, Mr. Person with responsibility, or Mrs. or Ms., you had a responsibility to protect this individual, and you failed to do it without reasonable excuse. Meaning you were fearful of death, you thought something would happen to your family, lots of excuses. So I'd like to get your pinpointed submission on that category of person that a court has said, look, you are a danger, and you in a sexual environment ought to have done something. The second category, if I could just put it this way, with respect to persons living off of prostitution, because the Sexual Offences Act criminalizes that category of persons, but that category is of two types. One, the person who is promoting the prostitution and lives off of the wages of the sex worker, and secondly, the sex worker. In recent examples in Trinidad and Tobago, we have found situations where persons have not only found themselves in the news for alleged perpetration of child abuse, the raping of young women forced to go on to drugs, etc., and put into organized prostitution. Insofar as that category of person could find themselves under Section 23, living off of prostitution in that environment, is your submission? Can you clarify your submission in that circumstance? Let me add one more, if I see you're taking notes. In treating with the tiered approach, and perhaps this relates to what Mr. Bagan said and other people, of course, the Office of the Attorney General takes note of other jurisdictions who have passed through tiered approaches after having come from a strict registry where they have the ability to collect data, and then they go into the tiered system. So I'm not aware of a fresh-grown tier unless it's recent on the back of other structures. But in that tiered approach, could you give me your views in relation to a judge of a high court deciding who ought to or who ought not to go onto a register? Or, if it's put in the alternative, a judge being invited to show cause why somebody should not go on, because that may potentially capture the situation of the person who is a victim of incest and the family stepping forward to say, look, you're going to shame our entire family in this matrix. Judge, would you consider not putting this person on? So that is both victim and relative, as well as offender, because the clauses in the bill already contemplate an offender saying to a judge, don't put me on the register. May I have your views on those pots of categories, those two categories?
Thank you for your questions. I'll try to address them succinctly. But just to add, consider my colleague at Kaiso, should the appeal be successful, the association would also want to add a third category who should not be on the sex offender registry, that of persons of consensual same-sex activity.
If I could just stick a pin?
Yes.
That has been decided by a high court judge at present in the Jones matter, yes. And the law has been read to be construed that way. That is the existing law right now. So it's on appeal to the Court of Appeal and ultimately to the Privy Council for the sole purpose of settling the law. And for the record, once again, I'll say, the government has taken the approach to appeal that matter because it relates to 27 other laws that are potentially discriminatory in that regard. And therefore, it is useful to have the highest court of Trinidad and Tobago, which is the Privy Council, decide upon that issue. But for the record, the law has already been changed pursuant to the judgment of the High Court in the Jones matter.
Understood. Thank you. Pertaining to the mandatory reporting issue you mentioned, I think one of the biggest factors at present, which informed our comments, was the fact that currently the mechanisms for and the protocols for reporting are unclear in terms of what are the responsibilities. Is that clearly stated? Are there clear guidelines for the reporting? Because as I mentioned, if these guidelines are unclear, if they are prohibitory, if they deter people knowingly and unknowingly, so it makes it difficult for them to do so. Also, what information do they need to provide? So, for example, other jurisdictions suggest you don't need to have proof of an act, you just need to have a sense that abuse has occurred or an offense has occurred, and therefore you're mandated to report. So you just need to provide the name of the child and who is involved, full stop. So in terms of what is involved in the reporting, is there some follow-up that you would need to have to attend? Do you need to physically go to the police station, or is there an officer who you can call and they come to you, etc.? So with respect to the mechanisms and that protocol, I think currently, because it is unclear, it leaves too much room for not, I would say, people to have a justifiable reason for not reporting. But as I said, if we want to engender behavior change, then we need to make sure that the mechanisms that promote positive behavior change are there. And it is for that reason mainly that we have a concern about mandatory reporters being on the list.
So to be direct,
yes,
in a circumstance where a court of law, having considered the situation that you've just described, it was unclear, it was not, the Education Act didn't tell me how to do it from the teacher's protocol. Doctors all of a sudden become unaware of their training and obligations inside of the regional health authorities, etc., which are quite clear, or an objective person in that situation who ought to have known in a fiduciary capacity that they had an obligation. Assuming all of that is aside, because it's considered objectively, I'm asking a question. If a court of law has said to someone, you had an obligation to report and you failed to give a reasonable excuse, a justifiable excuse, which is a subjective stroke objective semi-consideration, your position is that that person should not be on a register? And if so, could I get your views in relation to how we tackle the underreporting issue in this country, which is, as I'm told, near 84% underreporting?
One of the considerations for being on a register or not is if there are additional prohibitions. So, for example, if being on a register prohibits you from working in certain contexts or being in certain areas or interacting with certain populations, I think that's a very important consideration, given that the large category of mandatory reporters are people in professions who are delivering services. I think that's one consideration. My apologies.
The pimp. I'll put that issue that way. If you understand what I mean, living off of prostitution.
Yeah, certainly our comments were not directed towards people like those who we think are fall under the heinous category of offenders who should have consequences. I think we were speaking about sex workers who, for different reasons, conditions, contexts, should not be considered in the same category as people who are engaging in the trafficking or the pimping, as you put it, out of workers. So no, we don't agree with the...
Is there a recommendation as to how one ought to cast in law? It'll be the first time in this country, if it were accepted, who and what a sex worker is and how that is to be treated? Is the view of the association that sex working ought to be lawful in this country? Because that's essentially an element of this discussion.
I will not, at this moment, venture to give a position on behalf of the association when we have not discussed it. So I would reserve giving a definitive statement on that.
But however, the position is that the sex worker ought not to be.
I think there's room for consideration for how sex work should be considered and contextualized and treated in society.
Insofar as law must be prescriptive and precise, I'd be very grateful if your association could go back and consider and provide us with a written position on who and what circumstances sex working involves and how your association views that issue to be treated here. Because, and I'll tell you why I'm asking you that. Currently, in Section 23 of the Act, people who live off of prostitution are deemed to be guilty of an offense. And therefore, from the association that you come from, which is no insignificant association, your perspective is very meaningfully important to this committee and to me in particular. So I'd be grateful if you could go back and consult. I accept that you can't volunteer an individual perspective, but I'd really like to have that perspective on this concept of sex working.
Just on your last point, before I let my colleague respond, I think she wants to address the sex worker issue.
I just wanted to mention that when we're talking about sex workers, we're talking about prostitution, we are talking about a population which includes many, many underage. So that is also a consideration that has to be taken into account. You're not only talking about people, women and men, 18 and over, you're talking about a huge number of underage prostitutes. So that is a consideration in terms of their being on a sex offender registry. They are essentially in prostitution being perpetrated upon.
Okay, thank you. I just want to invite...
Sorry, there's one answer that's outstanding, if you don't mind, that's very important. It's on the tiered approach, which also coincides with what was last said.
Yes.
And my question was, would you be satisfied if that was a judicial determination as opposed to a legislative categorization? You are in tier 1, you're in tier 2, you're in tier 3, legislatively versus a judge deciding in what situation or in what circumstances and who should be put on a register?
We would be satisfied with the inclusion of professionals such as forensic psychologists, clinical psychologists, and other professionals who are experts in risk assessment. So we would be satisfied if the courts were to request such assessments by professionals and to have a report presented by which that determination can be made. The process of risk assessment and the ensuing categorization of low, moderate, or high risk is based on standardized, validated measures. For example, consideration of static and dynamic factors for risk of offending. There are a number of different instruments. So what we're talking about here is a discipline-specific and specialized process that takes place, and we would be very pleased if the court were to include consideration of having professionals be requested to make such assessments. We heard the mention of intellectual disability or low-functioning offenders. So this assessment could be widened to not just a risk assessment or a psychosexual assessment, but also an intellectual assessment, as much as is needed for the courts to be able to make the most informed decision.
Thank you.
Okay, thank you very much.
I have a question for the AG, please. I have a
question
for the
before you do, I want to invite the members who have questions to ask, and then we come back to you. Starting with Member Chote, Member Richards, Member Dial Singh, and then we'd come back to Kaiso.
Thank you, Mr. Chairman. Dr. Khan, I just wanted to jump back a bit to when you were speaking about the duty to report, the mandatory reporting, and you were saying that there ought to be protocols put in before you enact that kind of legislation. Is it your view then that if there are protocols, it will make it easier for there to be a determination as to reasonableness?
I think two things, and my comment would also relate to what Senator Richard asked earlier about whether there were aspects about our society or local context that would influence this. And I think one of the things we have to consider are perceptions. So people's perceptions of trust in the integrity and fidelity of systems and institutions. So therefore, is there enough incentive and motive for me to report the crime? So after I make the effort and I take the risk and I report the crime, do I have confidence now that this is going to come to an end and we will see justice done? So I think there's a bigger picture that needs to be taken into consideration about what are the different factors that might cause people to not readily inform when they're supposed to. So just to make the association's position very clear, that we fully support mandatory reporting. One of our suggestions even expands the scope for reporting. There are some jurisdictions that requires all citizens to report. So we are very much in support of mandatory reporting. However, there needs to be the support to enable this to happen. So I think psychoeducation, I think public awareness, I think training forensic psychology training, sexual offenses training for all the stakeholders involved, including persons of responsibility, would be a very critical measure if we want to have a successful measure. At the end of the day, our outcome is we don't want to have a large number of people who are guilty or being convicted of not reporting. What we want is to increase the number, and I think this goes back to the question of addressing the issue of underreporting. So we need to think not just about how to penalize non-reporters, but what do we need to do to incentivize and support people who report.
Thank you, Chairman. Just in furtherance of your comment earlier on, do you think it will be useful in our context to include in that assessment or in the law what has been enacted in some of the jurisdictions whereby there is a psychological diagnosis after professional assessment of certain categories of offenders, pedophiliac as a pathology to be remediated, and it is documented that this person has a pathology. I know it's a controversial discussion in some areas, but with that diagnosis of the person, of the offender in a particular category, there's a set out remediation protocol as in DSM-5, etc.
So you raised 2 points. One is the issue of assessment, and the second is the issue of diagnosis. So first off, yes, I think we would very much support having assessment for offenders, for having forensic assessments and reports pertaining to their judgment, etc. Now, the issue of the diagnosis, we want to make it very explicitly clear that not all sex offenders have a diagnosable disorder. So not all sex offenders have pathologies. So the singling out of one category of pedophiles might actually, if we were to look at the data in the local context, we would find the vast majority of our offenders are not pedophiles. So I think we have to be careful about the use of labeling. Following up from that, the need for rehabilitation, I think it is very critical and crucial moving forward. That we have the arms of the system which will punish people rightfully for the acts they've committed, but we also, because the aim is they're going to be returned to the community, we have to figure out how to reintegrate them. So certainly
some
the
of them.
assessments. Well, I think if, as psychologists, we want to think that there are approaches for everyone. Whether they comply or whether they're successful is another thing. So I think that having so the assessments can also inform what types of interventions will be appropriate and for which typology of offender. So for example, the intervention for a sex offender who has committed incest would be different for another typology, and that we should consider it both for incarcerated offenders, those who have been released to the community, and group and individual interventions.
Yelsing.
To the Psychology Association. Well, we know that, if someone gets an STD, you may have, you have like herpes, it's a lifelong trauma. So you're traumatized anytime those lesions come to, it reemerges. If you have HIV, you have to take medication for the rest of your life. So in a case, compensation for STDs, it's well established. There's the trauma. But what about the victims who have the psychological trauma? Because remember, I've seen victims who for years, they have to come to clinics, they have depression, they have to take medication that is very expensive. Sometimes they read some things in the news and they have to go back into therapy, they have to come back for CBT, they have that, so I'm asking you in terms of treating the victim, because I think right now we have gone so much in treating the perpetrator. And parts of the Act do look at the fact of compensation, to pay compensation. I think it is Section 35 look at paid compensation for the complainant or his representative for cases like STD. But I'm looking at now paying the victim, or even, let us say you have a victim whose relatives know you have been raped and abused. That parent may also undergo stress and depression, say, I'm failing as a parent. So even for the psychological treatment of the victims and their relatives, I want your take on that, how as an association, because I've been seeing clinic patients for years who are coming to clinic, and their relatives also have that feeling of guilt and helplessness.
Thank you, Senator Dayal Singh. Certainly, we agree with you for the need for a victim-centered approach. It is highlighted in one of our recommendations in our formal submission. And I think the victim-centered approach focuses not only on the victim after, but throughout the process. So we make recommendations for review of the current procedures for investigating and prosecuting sexual offenses, with an aim to focus on a victim-centered approach. What do we mean by this? That the process of having to go through the prosecution appearing at court doesn't further victimize and traumatize the complainant. So examples of that might be having, let's say in the case of children, having child advocacy centers where they don't have to go to multiple places, or they don't have to be giving the same information over and over. Research suggests that a child may have to give their statement between 6 and 12 times before their procedure is complete. So in terms of limiting their engagement with the court and also having therapy available throughout that process, it may take years for a case to be completed. With respect to the therapy and counseling services available to victims, we agree that this should be a priority. We note, however, as you know, currently every single public institution in the country where psychological services are available, there is a massive waiting list. So certainly, currently we don't have the capacity to offer these services to victims. So if we want to adopt a victim-centered approach, we will have to figure out how to prioritize and address resources specifically for addressing this. So be it bolstering the services that are offered by associations such as Rape Crisis, or having even more dedicated services.
Thank you very much, Dr. Khan. I want to ask Member Choate to ask the final question from the committee, and then we would have the opportunity to hear a final submission from each group, starting with Dr. Nixon, who has been waiting for a long time. So Member Choate, Dr. Nixon, and then the remaining entities with your closing submission.
Thank you. Well, perhaps I can make it easy and simply pose my questions to Dr. Nixon. What I wanted to know was Kaiso's view with respect to notification of partners. That is to say, where you have a virtual complainant who has died, and an STI or a virus has been communicated. I'm not sure my medical language is correct, but you get the gist of what I'm saying. Should there be notification to a spouse or partner or any other family member? Do you think that ought to be included? And secondly, because the follow-on of sexual offenses may not stop with the victim, do you think that partners, and I don't necessarily mean spouses here, that partners should also be included in the consideration for compensation? Because compensation may very well mean monies to pay for therapy, monies to pay for drugs and that kind of thing. Do you think those two things should be included?
Hello. Well, I guess almost good afternoon. Thank you for those questions. We support notifications of partners as long as it's within a victim-centered and survivor-centered approach, and so that our position, along with the coalition of NGOs and what we've submitted to you today, is that any legislation that moves forward must include a case-based restorative justice and victim and survivor support mechanism, and that be a priority for any legislation that goes forward. And so that's really what we want to continue to support, as well as our addition today around duty, that those who are on a need-to-know basis and those who are in service and duty to vulnerable groups in particular have access to a private register that would make the register serve justice. And so one of our concerns today, and we want to ask the Attorney General directly, please, what happens if the government wins the appeal? How will that impact Sections 13 and 16 of the Sexual Offences Act? And I'm happy to answer other questions directly, also from a survivor perspective, if that is what the committee is interested in hearing, but you do have a statement from me personally.
Thank you. Member Amdeen.
Thank you, Mr. Chair. Dr. Nixon, I had just looked at the order that was made by Justice Rampasad in the Jason Jones matter, and I want to ask you, would your organization and those persons that you represent be more comfortable if the legislation as presented in the bill that we are considering now be read as inserted, with this particular section struck out in one section and the particular section inserted in section 13, to read exactly what the court declared? Because while we are here saying that you are reassured or you've been given assurances, the High Court, which is the Supreme Court under the Constitution that declared Mr. Jones's constitutional rights to be what they are as reflected in the order, as we speak now and as we consider the legislation, that is the law. And would you not be more comfortable having the legislation reflect what the law is as presently declared by the High Court in terms of the content of those sections that you have spoken about in your submission? Would that give you the assurance that you are looking for, or would that accord with your understanding of the order of the court?
If that were added, then absolutely yes. I think that would assure our organization and the community that we serve that in the case of the appeal going through, that our community would not also be subject to being placed on a register. We would have to then, of course, tackle the 27 laws and deal with those levels of discrimination. But at least for the purposes of this legislation moving forward, we wouldn't be concerned about it being an additional discriminatory act for consenting adults engaged in same-sex sex acts.
Okay. Thank you very much. I want to invite the Organization for Abused and Battered Individuals to make your closing submission if you have one, followed by the Rape Crisis Society, the Institute for Gender and Development Studies, and we'll close with the Trinidad and Tobago Association of Psychologists. Thank you.
In relation to compensation, determination of compensation to the victim, under the new Section 36 of the Act, it basically states that the Criminal Injuries Compensation Board ought to be the body that would determine what compensation would be. But the concern here would be what methodology would be used, the re-victimization of the victim, and whether this compensation mechanism, because it's not one that victims are entitled to, but whether or not this compensation mechanism would remove the burden from the state from developing supportive, substantive, effective response, sustainable and tangible programs and support services to respond to victims of sexual assault. And to conclude, we recognize that sexual violence is a significant public health problem in Trinidad and Tobago, and while we applaud the legislature's effort to decrease the incident of sexual assault on victims, we are mindful also of the collateral consequences which may create an ominous environment which also inhibits the successful reintegration and rehabilitation of offenders. So while we are happy that, we have legislation to prevent incidents of sexual assaults, on the balancing end, we have to also be mindful of how offenders are treated and reintegrated and rehabilitated. Thank you.
Thank you. The Rape Crisis Society.
At the Rape Crisis Society, we are satisfied with the specialty court and having a robust NGO involvement in order to assist victims not only for their preparation for the court matter, but throughout the period of time that they need to be psychologically and emotionally stronger to move on. We have also expressed this position in a letter to the DPP last year, and this is in keeping the overriding objectives criminal justice system, and we are prepared to assist victims to go before the court, to give evidence before the court, and to move further after the court matter has been determined. We also reiterate with respect to their eligibility for compensation that some flexibility be given in these matters so that they can access whatever compensation is available to them outside of the one-year schedule. But we remain prepared to assist victims. We also assist the perpetrators in satisfying these overriding objectives and having persons who are reestablished, integrated, and can move forward in Trinidad and Tobago.
Thank you. The Institute of Gender and Development Studies.
Thank you. We will expand further in our submission when it comes on Thursday morning to say right now 3 key things. One, which is that the Break the Silence research on child sexual abuse and incest continues to emphasize that child sexual abuse is normatively accepted in widespread ways across Trinidad and Tobago, and that this remains the key context within which those on the register, their families and others now will be facing the consequences. And so for that to be taken into account, where it is that child sexual abuse is normatively accepted and where it is that there are greater punitive, where the punitive measures are expanded, it may be that there is a reduction in reporting, or at least there's greater vulnerability around reporting if it is seen to further disempower perpetrators, and so to take that into account. Secondly, the recent 2018 survey on violence against women suggests that the rates of sexual violence against women are by partners and non-partners are so high and yet result in so few convictions that were the justice system to work, there would be so many perpetrators on the register in Trinidad and Tobago. If 20%, 15 to 20% of women are reporting at least one experience of sexual violence in their lifetime, what percentage of male partners are we now thinking of putting on the register? Without rehabilitation and restorative justice approaches being mandatory as part of the legislation. And if the justice system doesn't work as it currently is not working in terms of both encouraging reporting and then getting those reports to conviction, then the register will continue to hide the true levels of impunity that exist in a widespread way across the society. And then finally, we would like to emphasize that around legislative changes, and this is what we've seen with the Domestic Violence Act across the region, that unless there are appropriate and significant and integrated cross-sectoral protocols of various kinds, that the legislation never works the way it is intended to work. And in fact, that victims, witnesses, and others can be further disempowered in the process of it. And so that there is a cross-sectoral approach so that this legislation can have the kind of efficacy that it's meant to. Finally, we'd like to emphasize the recommendation for a specialty court and, of course, mandatory treatment, which is rights-based rehabilitation and restorative justice centered upon conviction.
Thank you. The Trinidad and Tobago Association of Psychologists.
Thank you. We've had ample opportunity to express our comments. I just have one closing recommendation. I think it won't be an overreach given the scope of the problem to categorize sexual offending in our society as a public health crisis. And I think it needs to be addressed at the societal level, but also at the level of the professionals who are tasked with promoting justice. So to that end, we do, notwithstanding the establishment of a specialty court, we recommend sexual offense training, forensic psychology training for all magistrates, judges, justices, law enforcement, child protection, and judiciary officials. Thank you.
Thank you. And I'd go back to Dr. Nixon, who has been taking excessive notes, faster than the CAT reporters, for your final comment.
Well, now that the Attorney General is back with us, Kaiso wanted to ask a direct question. about what, and to the question raised earlier by Senator, that if the legislation would include assurance that under the current law, that sections 13 and 16 do not apply to consenting adult same-sex sex acts, then we are asking what happens, we were wondering what happens if the government does win the appeal. While we are all hopeful that that doesn't happen, we are concerned that if it does happen, well, would this legislation moving forward, what are our assurances that this legislation would,
I got you.
would follow the law as it exists currently?
Sure. As I've taken my time on numerous occasions to publicly state, and in particular to Mr. Robinson as well privately, the government has taken a very careful approach to this to settle the law. We can give no assurances at this point because it would be irresponsible to do that in light of what I've said already, because we're awaiting the decision. If it goes to the Court of Appeal and the government wins, it's going to go to the Privy Council. That is the intention, so that we can have the law settled from the highest court. In those circumstances, after we have had the benefit of the Privy Council's decision, the country would be in a better position to know what the parameters permissible are across the spectrum and not just one piece of law. As I've said before, there are 27 other laws that are impacted by this. So I regret that I can't give you the assurance that you're seeking at this particular moment.
As Senator Ramdeen suggested, is it possible then to write into this legislation from the perspective of the law now?
I respect that you're a strong advocate for your cause, and you're effectively asking me the question in a different direction. I can give no assurances for the very reasons that I have just volunteered and that I have on umpteen occasions previously.
Thank you. Member Ramdeen, you have a question? Microphone.
Sorry, to Dr. Khan and to the Institute. If we were to consider giving a discretionary power, whether it be to the court or otherwise, as to whether someone's name should be placed on the register, one of the main concerns that any tribunal that would have that power would be the same shopping list that you were indicating, the risk assessment factors that one would probably have to assess and to consider before that decision could be made. Could I ask the Institute, through you, Mr. Chairman, could I ask the Institute, in your submission that would be submitted, can you suggest what that shopping list may entail for any tribunal to properly consider what are the risk assessment factors or what are the other factors, including risk, that would be properly taken into consideration in making a discretionary decision as to whether someone ought properly to be, someone who is convicted ought properly to be put on a sex offenders register? Because there may be risk factors, there may be societal factors that you all would be much more in an expert position to suggest. If you could just indicate in your submission that, it would be very, very helpful to the committee.
Thank you very much. I want to thank all the entities for first responding to the request for written submissions, for providing high quality and detailed submissions, which meant that the members did not ask as many questions as they would have on previous occasions, for coming before us and amplifying your written submissions, and clearly persuading us in some regards for further consideration and discussions. I want to thank the members of the committee and the technical support from the Office of the AG and the CPC, and I always have to thank our Secretariat from the Parliament. This meeting would now adjourn to Thursday, March 21st at 2:30 p.m. And for the next 3 sessions of the committee's meetings, the committee will commence its clause-by-clause consideration of the bill in view of all the comments which we have received from the stakeholders who have appeared before us, have made written submissions, and from other sources where we've been able to get contributions on this bill. So the committee will meet again on Thursday, March 21st at 2:30 p.m. Thank you very much. This meeting
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.